Hi, this is Steve Carlson, and I am introducing here a second video, really talking to the Minnesota Supreme Court. Has actually been filed with them, that tells them what went on here with Al Franken and his contest was not what was required by Minnesota law, and this has got to be fixed. Al's certificate has got to be revoked, invalidated. We got to go through this contest here, Al, before he can be conforming with Minnesota law, so we're represented by somebody under law. Now, Al's always made a big point about we have two senators. Well, yeah, but those senators have to be selected according to Minnesota law. It just doesn't matter that you're out there, Al. You have to be selected according to the law. And bashing a contest here in Minnesota is not allowed by law, and we got to fix it. Somehow they made a big mistake, Al, when they released that certificate to you. And this is to the Supreme Court how we have to fix this now. All right, this is a summary and introduction of the argument in his actual appeal that I've submitted to the Minnesota Supreme Court today. And the first point I want to argue is the panel's action continues to violate the state's comprehensive congressional election code, which we're required to follow under the U.S. Constitution by Section 4 of Article 1. Now, the new preeminent congressional election contest criteria pronounced in the ruling, where they said the central purpose of congressional election contests, the efficient and decisive issuance of a certificate of election is the central purpose, that these deprive a contestant and the people of the state of Minnesota generally of the, quote, numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved. And this comes from the United States Supreme Court description of Article 1, Section 4. And these comprise and are mandated to comprise the state's CCEC, again, the Comprehensive Congressional Election Code. And I get this from Smiley versus Holm, the 1932 U.S. Supreme Court case, but also the 1972 Rodebush versus Hartke case, 405 U.S. 15. See also Franken versus Palenti. That was in 2009 between Al Franken, who should know this stuff, but he just won't get it. And Tim Palenti was the governor who, unlike Dayton, refused to just give Al the certificate because he had to go through this contest first with Norm Coleman. Al didn't want to go through that. Once he got ahead, he wanted to stop the whole show and head out to New York. Washington. I guess that's the New York way. You know, they don't mess around. Now, the CCEC established in Minnesota, however, under Section 4 requires that arbitrary, capricious, and deformed proceedings, as occurred under Franken's motion to dismiss, can be and must be voided, and recertification sought. Beyond that, neither the panel nor this Supreme Court of Minnesota have the power to limit the operation of the code within the ambit of the numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved. And this does involve the Minnesota Rules of Civil Procedure. And the biggest problem here, as the Notice of Contest explains generally, is that this court, the Supreme Court, does not meet these constitutional requirements in that CCEC and pronounces narrow obligations under the code, refusing to enforce those procedures and safeguards created by the Minnesota legislature. Perhaps the clearest case in a congressional contest is Franken's case, which in the order calls Palenti, which can be misconstrued to restrict any contest to merely verification of the vote count in a congressional election, and which Franken obviously took as carte blanche to violate these requirements of the CCEC at will, and for his party to violate them at will, and also allowing him to reach across the aisle with the Republicans to bar the Independence Party from all his debates. And Mark Dayton, who illegally issued Franken a certificate of election December 19th, also took the hint, apparently the Palenti case itself, that he could use the Independence Party nominee Hannah Nicollet in debates against Jeff Johnson, his opponent, only when he felt she should be allowed. This has deteriorated into a new rule this court pronounced, again erroneously, in my petition to this court in fall of 2014, that the Independence Party, as a major political party, did not need to be invited to participate in publicly broadcast debates governed by the Equal Protection requirement, but also by the First Amendment and the CCEC. This court through its negligence and disregard for the First Amendment and the CCEC, the legislature passed, or the equal protection requirement, has ushered in a new era, democracy by invitation only. This is a shallow farce of the democracy our Constitution not only requires, but without which we may not continue to exist as a nation. This is not sound and fury signifying nothing, as Franken jokes in court filings responding to my motion to void. So, this was enabled by a widespread misperception of your polity holding in the Franken petition of 2009, that you would not enforce the entire 209.12, but just the first two sentences. Secondly, I want to argue that the ruling would establish pernicious public policy violating U.S. Constitution and law. Now, upholding this unconstitutional reading of the CCEC would establish an unconstitutional pernicious public policy of haste. For a statement by your court in Polenti on temporal mandates in the CCEC at 2, you say, none of the provisions cited by Franklin expressly obligate the governor to deliver a certificate of elections by a date certain. Now, here they're talking about Polenti, his opposing party, the Republicans. Nor does Article 1, Section 4 expressly require state legislatures to structure the times, places, and manner of holding elections for senators, specifically so that newly elected senators will will in every eventuality be seated by the date Congress has designated for the beginning of their terms. Franken cites no authority that construes these provisions as creating the temporal mandate that he posits, unquote. But here, for some reason, the panel yields to the temporal mandates Franken posits. And what is the difference? And of course, the difference is, one, he just wants to talk about the vote count. He doesn't want to talk about how he won. Like Fidel Castro doesn't want to talk about how he won. He just won, right? Get it? Castro won. Well, Franken won. And he doesn't want to talk about how he did it or how the DFL conducts its shady business and things like quotas and endorsements of candidates and making all decisions for the party, various things that I've discussed in this. And however, this question of temporal mandate is something that Al Franken pushed. Essentially what Al argued in that first case against Polenti is this. He said, well, there's two senators from Minnesota, aren't there? I mean, he went to Harvard. He knows the Constitution says there's two senators. Bill and Ann Coulter, I hope you're picking up on this because Al is really weak here. Okay, but there's two senators, and they're supposed to start somewhere like January 3rd. So it's a violation of the Constitution, Al said, if he doesn't get out there right away, because they won't have two senators like the Constitution requires, and he won't get out there by January 3rd. This is against Coleman. So he got out there like in June sometime, and that's because there were some questions about how he got out there. I would say he was the choice of the court. But anyway, if you uphold this ruling, I'm telling the Supreme Court, you're going to establish this pernicious public policy of haste and getting people out there as fast as they can. And in efficiency. They're talking about efficiency, but look at this contest. This is hardly efficient. This is a parody of efficiency. It's like a Saturday Night Live skit on efficiency. It's not efficient. And this contest then amply demonstrates inefficiency. And this would encourage candidates for Congress in election contests, whenever there's a close count or questionable practices by a party, to establish baseless temporal goal lines to move the ball across in order to moot, quote unquote, any questions regarding their right to office where irregularities in conduct of the elections or serious, deliberate, and material violation of provisions of Minnesota election law are raised as points in those contests. In other words, I'm saying Minnesota's clear policies to prevent candidates from assuming elective office based on invalid elections is good public policy promoting the objectives of the Constitution and federal law. And these will be struck down if the panel's ruling prevails. A word about mootness. What's mootness? Mootness means, well, we don't even talk about that anymore because it's irrelevant now because time is water under the bridge. First, the only question which becomes moot when the Senate acts January 6th, to seat a person referred to them by the governor as selected and duly chosen as senator by a state is the seating issue. Now again, they weren't selected under Minnesota law because the contest was still going on, and they weren't duly chosen. And the governor said a false thing when he said that there was no contest and he was duly chosen, Governor Mark Dayton. But that is not the question before this court or panel, who to seat. The issue is whether, in fact, Section 4 authorizes the proceedings there, down at the panel. And in this case, would it allow the voiding of the orders and judgment entered there at the panel in violation of 209.12 and the invalidation of an election certificate issued in violation of 204C.40 subdivision 2, which again bars the issuance of any election certificate when a election contest has been filed and is pending until it is finally determined by a court of competent jurisdiction. Now, obviously, neither of these actions of checking out whether the law is followed would frustrate the ability of the Senate to make an independent decision on the seating decision that has already been made. And so ensuring that Minnesota law is followed, is duly followed, is not a moot issue, and is also not going to hurt the Senate. Now, the court and this panel have already said, the Supreme Court has already said, I am free to contact Ramsey County District Court and request the forwarding of the record of this case to the Senate, and no one argues this violates Section 5. So the issue is, in ensuring Minnesota law is followed by invalidating the certificate issued and following the full scope of 209.12, is that an infringement on Section 5? And it is not. The issue here is not whether it is a bother for Al Franken, currently Senator Al Franken, but whether it frustrates his right granted to the Senate under Section 5 of Article 1 U.S. Constitution, and it does not. So it should be voided, and we should go through the contest as set out in our Minnesota law. CCEC, what's that? Comprehensive Congressional Elections Code. That's what I derived that from the Smiley versus Holm case, and from the Rodebush case. They talked about a comprehensive code of congressional elections. Now, under the United States Constitution, the United States Supreme Court has held in Smiley Supra a Minnesota case which determined whether the sitting governor could veto congressional redistricting plans passed by the legislature. That Section 4 mandates the Minnesota legislature to prescribe a complete Congressional Election Code, CCEC, which establishes the safeguards required by the United States Constitution of our congressional elections. Chief Justice Hughes wrote for the Supreme Court in Smiley, quote, these comprehensive words, just 3 little words, time, place, and manner of election of members of Congress, embrace authority to provide a complete code for congressional elections, not only as to times and places, but in relation to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In short, to enact the numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved, unquote. This Hughes statement clearly shows that the CCEC is not limited to the narrow focus of this court to ballot questions and tabulation of the count, nor to the new central purpose and criteria and so-called statutory restriction under 209.12 advanced in this order. And accepting this would establish the pernicious public policy complained of. And the legislature has not, and no state would be permitted to, limit the ambit of their CCEC or contest provisions to just the highest vote count. But as Chief Justice Knudsen, this is of the Minnesota Supreme Court, in a case called Oligard versus Olson, that Al relied on in 2009, has said all the steps in conducting a congressional election must be regulated. Out of that footnote, I'm actually including some footnotes here. Now further, the principle applied in Pawlenty, that Indiana's contest provision in Rodebush had been upheld, applies here. Those powers of the legislature in enacting the CCEC must be recognized as being within the ambit of the state's own broad grant of authority under Section 4. Now, in Indiana, it was a question of whether they could do a recount. They seated one person in the Senate provisionally, and then the other side, of course, tried to stop the contest. And they said, well, Section 4 allows Indiana to go ahead and count the votes. So usually they're fighting over whether they can even count the votes, which votes can be counted, et cetera, et cetera. This is all very important. But there are things beyond that are important, such as protection of the voters, prevention of fraud and corrupt practices. All of those things are very bad for democracy. However, Rodebush, that case, did not, contrary to what this court found in Pawlenty, describe a contest procedure similar in all respects to Minnesota's under 209.02 and 209.12. Now, they think it is. The Supreme Court thought it was, but they weren't looking at this case. And in particular, the new explanation from the panel, which they just put out in the order, that they believe the certificate could be released December 19th by Dayton and Ritchie because the issue of the vote count is uncontested, and that they erroneously believe congressional contests are statutorily restricted in Minnesota to just accurate and regular tabulation of votes under 209.12. These errors rest on a misunderstanding of the Supreme Court of Minnesota's ruling in Pawlenty. In particular, this phrase from Pawlenty at 2 has been misconstrued to support the panel's erroneous finding. Franken versus Pawlenty, 762 Northwest 2nd, 558 at 569, Minnesota Supreme Court, 2009. Quote, in statewide elections for congressional office, the scope of the contest is statutorily limited to the question of who received the highest number of votes legally cast in the election, unquote. Italics added. Compare this to the order at page 8. In statewide elections for congressional office, the scope of the contest is statutorily limited to the question of who received the highest number of votes legally cast in the election. Very close similarity, yes. Thus, your dicta, mere words, in Pawlenty seems to have been misconstrued to exclude the second part of 209.12, but also the second part of 209.02, grounds. Specifically, all regularities, these can be grounds for a contest, all regularities in the conduct of the election, and all points of serious material and deliberate violations of Minnesota election law, including the CCEC, and they're all excluded from this new definition, this kind of brave new history or brave new world that Franken is promoting here. Now, in context, however, it appears that your words, Supreme Court, have been misconstrued. In Minnesota, the Pawlenty Court, with some changes in personnel, found, quote, Minnesota Statutes 209.12 explicitly acknowledges the Senate's authority under Article 1, Section 5 by limiting the scope of an election contest for congressional office to the question of who received the highest number of votes legally cast in the election. Moreover, by requiring the court hearing the election contest brought under Chapter 209 to preserve all evidence taken and transmit it to the Senate upon request, Section 209.12 does nothing to frustrate the Senate's ability to make an independent judgment as to which candidate to seat, unquote. Well, you can imagine who's frustrated there is Al Franken. Al Franken was frustrated that he couldn't just run right out to Washington like he's in a new wrestling match or something, run right out there and jump right in the Senate. And he was frustrated, but they said, no, we're allowed to have a contest to make sure that which votes are going to be counted. After all, Al was behind Norm Coleman by 220 votes, and then miraculously ended up 220 votes ahead once the courts got through with it. And of course, the courts are well represented, along with some Mark Ritchie and people from his office on that canvassing board. Now, in the context of Franken's 2009 petition, insofar as it was material there, your statement was correct, but only because Coleman's contest was restricted to the issue of tabulating the votes. Another source of the court's error in this statement is the implication that because the count issue is the only one in which the legislature, through the CCEC, allows and or requires Minnesota courts to issue findings of fact and conclusions of law, that it follows that election contests are statutorily limited to that issue in the sense that the courts are not required to follow the whole contest provision by collecting, certifying, and forwarding evidence to the Senate. So while there is indeed a statutory limitation on the powers of the courts, there are also clear requirements not followed here of the courts in that statute. These areas are certainly not reserved by the legislature in the code for the discretion or refusal of Minnesota courts. The type of adjudication is different under the CCEC and limited to aiding the Senate. They can't decide these things, but they have to do them to aid the Senate under our law. Now, however, the contest was not, strictly speaking, statutorily restricted to that issue. And thus, in this contest, your polenti words must be construed as mere dicta, just words, not material to interpret the full scope of 209.12 or 209.02, which are the grounds for a contest. On the contrary, Minnesota courts are required by statute to provide a remedy for other issues which this court has found, not only in Sari versus Gleason, a mayoral contest from 1914, but also in Odegaard, are in the Minnesota Code and are in the ambit of Section 4 under the broad grant of authority to the Minnesota legislature. In Polenti, you also found Chief Justice Knudsen explained, quote, "The states have been given the authority to provide all steps necessary to complete the elective process, subject to the overriding power of Congress to determine who has been properly elected and to refuse to seat one who is determined not to have been properly elected." And that's Chief Justice concurring in that opinion. Yes, 209.12 is indeed to dovetail. It is intended to dovetail with Article 1, Section 5. However, for this court to conclude that in all contests under 209.12 and 209.2, they're limited to the grounds simply of who received the highest vote total would misstate Minnesota law. What must dovetail between Sections 4 and 5 must include, under the Minnesota CEC, all the statutorily permissible grounds. As Chief Justice Knudsen put it, all steps necessary to complete the elective process, unquote. And in particular, all irregularities in the conduct of the election and all points of serious material and deliberate violations of Minnesota election law, including the CCEC. And this is precisely what is alleged in my notice of contest. And on these points, apparently for reasons now made plain in the order, the panel has failed and refused to allow the law to operate. They've blocked the contest improperly. In Polenti, you further noted that after the Odegaard case, 1961, the CCEC had been rewritten with the purpose of including a congressional contest provision, 209.12, beginning in 1963. And again, this law is of a special sort, like the congressional redistricting powers of the Minnesota legislature at issue in Smiley. And so this court is not free to change what the legislature passed, and therefore it must enforce it in the matter of the election of the office of U.S. Senator as written, as prescribed. All of the grounds presented in the notice of contest fall under some particulars listed by Chief Justice Hughes in Smiley. A good example would be protection of voters. This is done through the Constitution and its provisions as set forth in the notice of contest that I submitted December 2nd. The protection of voters includes our right to associate freely as independent voters in the Independence Party. That is to say, the rights violated as complained. The denial and abridgment of the vote by the DFL, but enforced by state statute, the right of freedom of association and expression by utilizing public information like the voter email addresses, and the right of access to the courts for redress of grievances in the elections. And another one would be being allowed to participate in the publicly broadcast debates when you are a nominee of a major political party. Those are civil rights which were violated by Franken and Dayton, and now they're trying to get away with it, and they're trying to run off, the Republicans and Democrats trying to run off and leave the memory of the Independence Party in the dust. You know, another one bites the dust. And certainly, these grounds are within the ambit of requirements as to procedure and safeguards, which experience shows are necessary in order to enforce the fundamental right involved. In other words, the Minnesota courts must fully remedy violations and present duties to safeguard First Amendment rights, abridgment or denial of the vote, departures from the requirements of Minnesota law regarding public information under the Minnesota Government Data Practices Act, and enforcement of the civil rights of Minnesota major parties and their candidates, and their meaningful inclusion in the election, including the right to appear in publicly broadcast debates, as required by the principles stated in Congress's equal time requirements. And these are actually part of the CCEC under Section 4, because they do override and regulate the law passed by the state. They're the ones that pass this equal time provisions. So that has to be followed. Now, this is the first time this particular matter is before this court, the Minnesota Supreme Court, in this contest procedure. And as the notice of contest sets out in 2012, you declined to find that the Ramsey County District Court had a present duty to allow that contest, similar in some respects to this one. Proceed. And I have said in the notice of contest that is a violation of the CCEC. So the points raised in this contest have never been before you. But the principle is the same. The requirement of the CCEC is the same, that you ensure that 209.12 and 204C.40 are lawfully carried out. And this includes the entire provisions, not just a piece regarding the vote count. And just to end this section, I have stated these two very important provisions of Minnesota election law. This one is called 209.02 contested, ground subdivision 1. And it says that any eligible voter, including a candidate, may contest in the manner provided in this chapter. The contest may be brought over an irregularity in the conduct of an election, or on the grounds of deliberate, serious, and material violations of Minnesota election law, unquote. And I think what I've just described are deliberate, serious, and material violation. The phrase Minnesota election law in a congressional race does not refer to the general election law of Minnesota, but to the comprehensive congressional election code referred to by Chief Justice Hughes. In all of the points alleged in the notice of contest, the claims, as Franken called them, fall within this ambit. And then here's what 209.12 congressional office contest says in part. Evidence on any other points specified in the notice of contest, included but not limited to the question of the right of any person to nomination or office on the ground of deliberate, serious, and material violation of the provisions of Minnesota election law, must be taken and preserved by the judge trying the contest. But the judge shall make no findings or conclusion on these points. After the time for appeal has expired, or in the case of an appeal after the final judicial determination of the contest, upon application of either party to the contest, and then we'll forward this to the U.S. Senate. Now, this evidence is to be certified and promptly forwarded with the certificate, not just a certificate without this evidence, because this is all part of the same contest to the Senate. Now, as in Rodebush, these matters referenced in Minnesota's congressional election contest law address points that are, quote, an integral part of the Minnesota electoral process and within the ambit of the broad powers delegated to the states by Article 1, Section 4. This is 405 U.S. at 25. I'm Steve Carlson, and I approve this message, and I will continue this on another video.